Under Florida law, there's a 2-year statute of limitations that applies to medical malpractice cases, and that really just means a deadline. You have a 2-year deadline from the date you have discovered or should have discovered that you were a victim of medical malpractice to file your claim. But in no event can a medical malpractice claim be brought beyond 4 years. This is called the statute of repose, and this is the deadline that applies from the date of the incident of medical malpractice and runs for 4 years. Now, there are some very narrow exceptions to these 2- and 4-year deadlines. There's an exception if there has been fraud. That means that if a healthcare professional has somehow covered up his or her medical negligence such that you could not possibly have discovered the medical malpractice. Another exception to the 2-year statute of limitations is the case of a minor child. If you're the parent of a child under the age of 8, you have until his or her 8th birthday to bring your claim for medical malpractice on his or her behalf. Because of these exceptions, it's important to bring your case to a medical malpractice attorney as soon as you think or suspect that you or a loved one might have been the victim of medical malpractice. You certainly don't want to miss the 2-year statute of limitations that generally applies.